All right, thank you. It's my understanding there's going to be a plea in this case, and I don't understand what this is about the habitual fourth on case 25-003851.
Is that the manslaughter case,
Yes.
Judge?
Your Honor, I'm sorry.
On that case, Mr. Burks was charged with a habitual violent fourth offense notice, and so they are taking off the violent offense notice so that there is no mandatory 25.
So he'll be pleading as a habitual fourth offender?
Correct, Your Honor, just not a violent habitual offender. Because by law, the court would have to sentence
Yep,
him to 25
I understand.
years.
Thank you.
Or
Sir,
the MDOC would do it.
Mr. Burks, you can come to the podium, okay?
Okay, Mr. Burks, come on to the podium. Can we have a copy of the plea form, please? You can start, Judge. I'm just going to grab a copy.
Yeah, I just want to have it in front of me.
Okay.
He can be in the first couple seats. He can be. Actually, you know what? He can be in the back. I don't want him up here. I'm sorry, sir. I apologize. We're on the record now. Sir, please raise your right hand. You swear testimony you're about to give shall be the truth?
Yeah.
Okay. Put your hand down. Can you state your name and age for the record, sir?
Desmond Burks, 35.
Okay, and you are a U.S. citizen?
Yes.
Thank you, sir. I have a settlement offer and notice of acceptance indicating on case 25-003857. On that case, you would be pleading guilty to a charge reduction. That's fine. You'd be pleading guilty to a charge reduction for count 2, second-degree murder, which carries a statutory maximum penalty of life. Do you understand that?
Yes.
You'd also be pleading guilty to count 3, larceny $20,000 or more, which carries a statutory maximum penalty of 10 years. Do you understand that?
Yes.
You'd be pleading guilty to count 4, using a computer to commit a crime with a maximum imprisonment of 10 years to 20 years, which carries a statutory maximum penalty of 10 years. Do you understand that?
Yes.
You'd be pleading guilty to count 5, felon in possession of a firearm, which carries a statutory maximum penalty of 5 years. Do you understand that?
Yes.
And you'd be pleading guilty to count 6, 7, and 8, felony firearm second offense, which carries a statutory maximum penalty of 5 years and a 5-year flat sentence in the Michigan Department of Corrections. Do you understand that?
Yes.
You'd be pleading guilty as a violent habitual fourth offender notice, which would require a mandatory 25-year sentence, which carries a statutory maximum penalty of life. Do you understand that?
Thought they just said.
Now, that's on the manslaughter one. On this one, you've got a 35-year sentence. This is, the HAB is a minimum of 25. So do you understand that?
So this is only regarding case 25-003857. So the maximum penalty, you would be pleading as a habitual fourth offender, which carries a statutory maximum penalty of life. Do you understand that?
Yes.
Count 1 of the information will be dismissed pursuant to this plea. Do you understand that?
Count 1 is the murder first degree.
Yes.
Okay, so the first degree murder will be dismissed. You understand that, correct, sir?
Yes.
Okay, thank you. There'll be a sentence agreement between yourself and the prosecutor's office of 35 to 60 years in the Michigan Department of Corrections, plus 5 years in the Michigan Department of Correction, and that would be on count 2. And that would be plus 5 years in the Michigan Department of Corrections on counts 6, 7, and 8, the felony firearm second offense. Counts 3 and 5, 3 through 5, there would be a sentence agreement between yourself and the prosecutor's office of 6 to 10 years in the Michigan Department of Corrections. That would be concurrent with the second-degree murder plea of 35 to 60 years and consecutive to That would be concurrent to the plea and consecutive to as well, the felony firearm. Do you understand that?
Yeah.
Do you understand that? That means they all run at the same time, except for the felony firearm.
Yes.
Okay, thank you, sir. And if you can speak up, I'm having a little hard time hearing you, so if you can just keep your voice up. Thank you, sir. Do you have any questions about this plea on this case?
No.
Okay. And is it your wish to plead guilty today on this case?
Yeah.
Yes, sir?
Yes.
Okay. And are you pleading guilty because you are in fact guilty to what you're pleading guilty to?
Yeah. Yes.
Thank you, sir. Now, on case 25-003851, you would be pleading guilty to count 1, manslaughter, which carries a statutory maximum penalty of 15 years. Do you understand that?
Yes.
You would be pleading guilty as a 4th habitual offense notice, which carries a statutory maximum penalty of life. It would not be a mandatory 25 years, however, it would be just as a regular habitual 4th offender. Do you understand that?
Yes.
Okay. And the sentence agreement on that case would be 10 to 15 years in the Michigan Department of Corrections. There'll be restitution if there is any. This would be concurrent to case 25-003857. Do you understand that?
Yes.
And do you understand what a habitual 4th offender means with regards to case 25-003857? This is the second-degree murder case, meaning that as a habitual 4th offender, all of the other counts carries a statutory maximum penalty of life. Do you understand that, sir?
Yeah. Yes.
Okay, thank you. With regards to the manslaughter case, case 25-003851, do you understand that plea?
Yes.
Do you have any questions about it in any way?
No.
And is it your wish to plead guilty on that case?
Say it again.
Is it your wish to plead guilty on that case as well?
Yes.
And are you pleading guilty because you are in fact guilty to what you're pleading guilty to on that case?
Yes.
Okay. Sir, do you understand that if your plea is accepted, you will not have a trial of any kind?
Yes.
And do you understand that you'll be giving up certain rights that you would have if you had a trial?
Yes.
Do you understand that you'd be giving up the right to have a trial by jury?
Yes.
Do you understand that you'd be giving up the right to be presumed innocent until proven guilty?
Yes.
Do you understand, sir, that you'd be giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes.
And do you understand that you'd be giving up the right to have the witnesses against you appear at trial?
Yes.
Do you understand that you'd be giving up the right to question the witnesses against you?
Yes.
And do you understand that you'd be giving up the right to have the court order any witnesses that you have for your defense to appear at the trial?
Yes.
Do you understand that you'd be giving up the right to not have your silence used against you in any way?
Yes.
And you understand that you'd be giving up the right to remain silent?
Yes.
And do you understand that you'd be giving up the right to testify at the trial if in fact you wanted to testify?
Yes.
Do you understand your constitutional rights?
Yes.
And do you have any questions about them in any way?
No.
Do you understand that if your plea is accepted, you will be giving up any claim that your plea was the result of any promises or threats that were not disclosed to me today, or that it was not your own free choice to plead guilty today? Do you understand that, sir?
Yes.
And do you understand that if your plea is accepted, you may be giving up the right to appeal certain issues that would otherwise be appealable if you were to be convicted at trial?
Yes.
You also understand that any appeal from conviction and sentence pursuant to your plea will be by what is called application for leave to appeal and not by right. What that means, sir, is you'd have to ask the Michigan Court of Appeals to review your case. You wouldn't have an automatic right for them to review your case. Do you understand that?
Yes.
Has anyone promised you anything other than what's been stated on the record today?
No.
Has anyone threatened you or forced you to plead guilty today?
No.
Is it your own free choice to plead guilty today?
Yes.
Okay. On case 25-003857, sir, I want to bring your attention to the date of April 22nd of 2023. Were you in the area of 150 West Boston Boulevard, City of Detroit, County of Wayne?
Yes.
And was there a individual by the name of Devon Hoover at that location?
Yes.
Did you have a firearm with you at that time?
Yeah.
And did you shoot Devon Hoover two times?
Yes.
And did he die as a result of those
Yeah.
gunshot wounds?
Yes.
And you intended, when you shot him, to commit great bodily harm at that time, correct?
Yes.
Sir, you took some money from him, including, and some things from him, is that correct?
Yes.
A white Range Rover SUV, keys, Samsung Galaxy cell phone, cash and credit cards, is that correct?
Yeah. Yes.
Okay. And those, you would agree, in value had more than $20,000, sir?
Yeah. Yes.
Okay, thank you. And you said yes, correct, sir?
Yes, I did.
Thank you, thank you. And when you stole these things, you agree that you didn't have any permission to have those things, correct?
Yes.
Okay. And some of the money that you received, you used your phone, a computer, iPhone, to transfer some of that money in a Cash App account to other individuals, correct?
Yeah.
Yeah.
Yes.
Thank you. You would agree that you had no permission to do that. You would agree with that, correct?
I agree.
Okay, thank you, sir. And with regards to, you had previously been convicted of a specified felony, correct? And you did not have the eligibility to possess a firearm at that time, correct?
Yeah. I think so. Yeah.
Yes? Okay.
Yes.
Thank you, sir.
What?
1 second.
What?
You also, just with regards to the previous record, sir, you were previously convicted of you were previously convicted of felonies, as stated in the information, September 3rd, 2008, carrying a concealed weapon, May 11th, 2011, weapons felony firearm, and these are all in Third Circuit Court in Wayne County, and on May 25th of 2011, arson of a dwelling house. Is that correct, sir?
May of 20 what?
May of 11th of 2011. This is in Third Circuit Court, weapons felony firearm.
I got convicted of that in January.
In January of 2011? Is that a yes, sir?
Yes.
Okay. Any objection to agreeing to that?
Your Honor, we can agree that Mr. Burks has previously been convicted of 3 or more felonies, one of which is a violent felony under the statute to satisfy the mandatory habitual court offense notice.
Okay, and you agree with that, sir, correct?
Yeah.
Okay. People satisfied with the factual basis of advice of rights?
Yes. Oh, people.
We're satisfied, Your Honor.
Defense satisfied with both the factual basis and advice of rights?
Yes.
Plea will be accepted. With regards to case 25-003851, sir, I want to direct your attention to the date of April 17th of 2024. Were you in the area of Greenfield Road in West Chicago in the city of Detroit, County of Wayne?
Of course.
And there was a person there by the name of Rita Soleil, correct?
Who? I don't know that person.
Okay, is there a stipulation with regards to the complaining witness and victim in that case?
Yes, Judge, we would stipulate that was the name of the individual that was in the incident with Mr. Burks.
Okay,
We
was
agree,
there?
Judge.
Okay, was some type of accident? Is that correct, sir?
Yeah, he smashed the back of my car.
Okay, and then at that time, did you punch him? And did you punch him at the time?
I slapped him. I didn't punch him.
Okay, you slapped him, and as a result, he hit the ground and died as a result of those injuries, correct?
No, someone dragged him from the corner, from the middle of the street. No,
What?
I didn't. No.
We would stipulate that as a result of those injuries, he subsequently died. He didn't die that day at the scene.
No, he
Okay,
didn't.
fair enough.
Yeah.
And fair enough.
Yeah.
Fair enough. So he died as a result of those injuries. Is that correct?
Correct.
Is that correct, sir?
That's what I was told. Yes.
Okay. People satisfied with the factual basis and advice of rights?
I mean, Judge, I think the defendant has to.
Just for a moment.
Yeah, we'll approach, just one second.
I don't sit down.
Yeah, you can stay there. This should be short, sir. Thank you.